So welcome. Thanks so much for joining us. This is another Proline Academy in our series for Strata Council members. My name is Catherine Squires-Basson. I'm the Director of Culture and Community here at Proline. We offer a number of different opportunities for learning, as you probably know now, if you've been in a few of these, for both our Strata Council members and some for our residents and owners in our Strata communities. So these Academy sessions, which are either presented by our own team members or sometimes with guest speakers like today, dive deeper into specifics around how strata corporations and communities function, and they're geared to you as council members, and sometimes, like I said, also community members. If you have any, if you have any questions or suggestions regarding these offerings, please feel free to reach out to me directly. I'm happy to take that feedback and get an idea of what you are looking for in the future. A couple of notes before we pass this over. Today's session is being recorded. We will send a link out to everyone who's registered once the recording has been processed. There will be time for questions at the end of the presentation, I believe. Please use the Q&A function, not the chat, to type in your questions so that they can be addressed all at once. And that's so other people can see if their question has already been asked, because you can see each other's questions in that function. One last thing, a webinar, so no one can see or hear the attendees. Only presenters will be on screen, so you can relax. You don't have to worry about that. If you do need to talk to me, you can send me a message in the chat and I can communicate with you through that. And now I'm going to hand it over to Christy Tambury, who's a Strata property manager and one of our managing brokers and one of the supervisors of our Strata management team, to introduce today's speaker.
Thanks, Catherine, and welcome everybody. We are talking about bylaws every strata should have and why they are necessary. And we've brought in Justin Hanson. Justin Hanson is a local Victoria strata lawyer. He has practiced with Stevenson, Luchies, and Legh since 2012, and I think before that, worked elsewhere for about 7 years. We've probably been working with Justin for about as long. His primary practice area is in strata property law. I'm not going to get too much into his background other than to say we're in great hands, and I'm going to hand it off to Justin to get started here.
Thank you, Christy. Just wondering, I've done a lot of teaching by Zoom. I have never used the webinar format. So will the attendees be able to send questions? If so, are they sending them through you, or are they going to pop up on the screen?
Yeah, so they will send questions through the Q&A feature, and at the end of the presentation, you and I can go through them, and I'll spit them out at you, and you can spit back some answers.
Perfect. That might make things go really quickly. And I know we're scheduled for an hour, should this presentation and the answers only take half an hour, I can jump on to another topic that's equally pithy right now. So
Awesome.
Without further ado, let's hop on to the topic you guys asked me to talk about, which is bylaws that every strata should have and why they're needed. Okay. All right, welcome everybody. Again, my name is Justin Hanson. I'm a strata lawyer from Victoria, British Columbia. I've been practicing strata law now since approximately 2008, 2009. So I'm almost 16 years into this. I've worked for about 1,000 different property management companies, and I work with the fine folks at Proline all the time. So I've had a lot of experience dealing with strata corporations, and one of the things that has hit home again and again and again for me is that many strata corporations attempt to muddle through life with an incomplete set of bylaws. And almost invariably, that results in some kind of a disaster sooner or later. It's not a matter of when incomplete, or not a matter of if incomplete bylaws will come back and bite a strata. It's only a matter of when. So what I've done is I've put together a list of seven bylaws that you may not have in your strata corporation that you really ought to think about adopting. I'm going to tell you what those bylaws are, why you should have them, and maybe give you some idea of the case law behind that, what the rationale is. Okay, so let's get underway here. All right. So what we're going to talk about is the importance of 7 essential bylaws that strata corporations in British Columbia should really consider adopting and why they're needed. The first set of bylaws that pop up onto my list is probably the most important set of bylaws. It's essential that you have repair and maintenance bylaws that clarify responsibilities between owners and the strata corporations. They prevent dispute over who pays for what repairs. They ensure timely maintenance, reducing cost in emergency repairs, and they support insurance claims with clearly defined responsibilities. Having good repair and maintenance bylaws is absolutely essential. More costly disputes are fought over repair and maintenance than practically any other item. People are always disputing who repairs this, who owns this, etc. And it's important that these bylaws are nailed down because in a strata corporation, the concept of ownership, the concept of exclusive use, the duty to repair, and the duty to insure, they don't necessarily go hand in hand. Okay. Sometimes you have to turn off your desire to apply common sense to strata law. It doesn't always follow. Most of us have come from situations where we owned single family homes. And in a single family home, if you owned it, you insured it, you repaired and maintained it. That is not true in a strata corporation. Here's what I mean. In your strata unit, you will have a beautiful kitchen. The kitchen, if it's original to the building, you own it, the strata insures it, and you repair and maintain it. Some of the older buildings, there are balconies. The balconies are in these older buildings, usually part of the strata lot. In those situations, most bylaws will set out that you own it, strata insures it, the strata repairs it. So ownership and repair and maintenance don't go hand in hand. You have to look to the bylaws to see who repairs what. The only thing that's inextricably linked is that if something is common property, the strata must repair it. There's no option there. But everything else has an option. And where that comes from is Section 72 of the Strata Property Act. Okay. So again, it's essential that you have very well-defined repair and maintenance bylaws. Many strata corporations don't. They're missing things. Complete repair and maintenance bylaws should do a number of things. They should set out who repairs what in a fair degree of detail. They should require owners to repair and maintain pre-existing alterations to their strata lots and limited common property. They should require owners to pay for strata's costs in repairing and maintaining alterations to the common property that they receive the sole benefit of. So these bylaws are necessary because there's often fights over repair and maintenance of existing alterations. Indeed, up to 2 minutes before I signed into this webinar, the opinion I was giving was who was responsible to remove and replace enclosures on 40-year-old enclosures on a balcony. Okay. It comes down to the bylaws. Strata Corporation had bylaws saying that the homeowners are responsible for that. Okay. So again, bylaws should deal with existing repair and maintenance of existing alterations. If they do not, that's a huge gap. And at some point, the Strata Corporation may find itself in problems because of it. Okay. So that's what I'm talking about in terms of the Strata Corporation being responsible for having a good repair and maintenance bylaw. The other thing that a repair and maintenance bylaw really needs to do is it needs to deal with hoarding and other hazardous situations within a strata lot. Hoarding is a common problem in stratas. It's something that I, as a strata lawyer, deal with every second or third week at the least. It's ongoing, and we see it in all types of buildings, new buildings, old buildings, buildings with young people, buildings with old people. It just seems to be endemic. It's everywhere. You need to have bylaws that define what hoarding is and then allow the strata corporation to take some steps to deal with the hoarding. Okay. Now, even though I'm saying that you need to have bylaws to do this, the bylaws really are more for information purposes in this sense. Strata Corporation does have limited powers under Section 133 of the Strata Property Act to go into a strata lot and carry out repairs, even in the absence of a specific hoarding bylaw. The hoarding bylaw just makes it easier and more precise. Okay. Finally, the other thing that the bylaw should do is it should differentiate between chargebacks to owners under Section 133, which is what we were just talking about, dealing with the hoarding, and Section 85 of the Strata Property Act. What Section 85 is it's the section that deals with things like, best way to put it would be things like the fire department coming into a unit and determining there's a fire hazard, or VHA going into a unit and determining that there's a health hazard in a unit. If the fire department or the Vancouver Island Health Authority goes into a unit and says, you have a problem in here that needs to be fixed, and grants an order to fix that, then the homeowner is required to carry out that work. And if they don't, the strata is then empowered to go in, do the work, and charge them back for it. The big difference between these two is that work done on the strata's own behalf under Section 133 cannot be liened. You cannot place a certificate of lien against the owner's title for that. Where if it's work done by a strata under a order of a municipal government or fire department or health authority, the strata can lien for that work. Okay. All right, so that's repair and maintenance. Very important bylaws to have. I strongly recommend that you take a look at your repair and maintenance bylaws at least once every 4 or 5 years. We're trying to avoid situations where you're just slapping a piece of duct tape over a major repair that's going to work. Have proper bylaws, it's better than a quick fix. Okay. Other essential bylaws. The next most essential bylaw is the enforcement bylaws. Um, Enforcement bylaws provide due process for enforcing the other bylaws. It talks about things like the notice, opportunity to respond, all of the procedure that's set out in Section 135 of the Act. It's really important that it outlines procedures for fines, penalties, and legal remedies. And the reason for that is because the BC courts have said over and over again, if you do not follow the procedure that's set out in the Act, you are going to have your fines and your chargebacks reversed. So if you send out a notice of complaint to a homeowner and that notice of complaint finds them guilty and tells them to pay the fine, that's going to be reversed. It's not going to be upheld by the court. So having a clearly outlined procedure that follows Section 135 of the Act in your actual bylaws prevents that from happening. Okay. The other thing it does is it provides strata corporations with mechanisms to enforce the bylaws. I'll talk a little bit more about what sort of mechanisms are available shortly. It reduces legal risk by ensuring procedural fairness. Again, that goes back to if you don't follow Section 135, your fines and chargebacks will not be upheld. Okay, that can get expensive. And finally, having a strong enforcement bylaw encourages compliance through transparent and fair enforcement mechanisms. If you have a good bylaw, it acts as a deterrent. Okay. So a well-drafted enforcement bylaw should apply to owners and tenants. I cannot reinforce this one enough. One of the things that we have seen over and over again is a situation where strata corporations enforcement bylaws refer only to owners. Usually we see that where the strata corporation had a rental restriction bylaw. Well, now that rental restriction bylaws are gone, you have to refer to owners and tenants because the case law is very specific. It says if you attempt to enforce a bylaw contravention directly against an owner without giving the due process to the tenant, that process is flawed and the fines and chargebacks will not be upheld. You have to give due process to the tenants. Fines are applicable to tenants. The bylaws for enforcement should refer to both. Okay. Quite common that it doesn't. Again, like I said in the previous slide, the bylaw should set out the Section 135 process for enforcing bylaws. That includes the notice, the opportunity to respond, the opportunity to have a hearing before the council. And it perhaps should even make note of a council member's duty to recuse themselves when there is a conflict. Already this morning, I had a case come in, a brand new case, where the lawyer for the opposing owner, who was making a complaint about council, pointed out 3 separate occasions where the council member against whom the complaints were being made sat in on the deliberations dealing with the complaint. That's a clear conflict of interest. It's contrary to Section 32 of the Act, and this should be spelled out somewhere in the bylaws so people don't make that mistake. Okay. It should also set out what a strata corporation can fine for a contravention. It should set out the amounts. The current amounts for fines are maximum of $50 for a contravention of a rule, maximum of $200 for contravention of a bylaw, maximum of $1,000 per night for a contravention of a short-term rental prohibition bylaw. It does kind of show you what the government's priorities are, that you could theoretically burn down your strata corporation and get charged a $200 fine for doing that, but they're going to nail you for $1,000 a night for having an Airbnb in your unit illegally. That's a little bit off, but who am I to comment? Going on from there, the enforcement bylaws should also set about what types of legal actions the council can take. Okay. There's 4 types right now that the council itself can authorize without a 3/4 vote. Those are forced sale actions. That's to collect arrears of strata fees. Small claims actions. That's to collect damages or loss or something like that, usually against third parties that are not part of the strata corporation. Eviction of problematic tenants. If nowadays under Section 128 of the Strata 138 of the Strata Property Act, you can actually evict a problematic tenant without the consent of the landlord. Since we've had the ability as a strata corporation to go through the residential tenancy office to do this, that was restored back in January of 2023. Since we've had this power, we've started to do this, and I think we've evicted 2 or 3 tenants where the landlords weren't doing anything. So this is definitely something that comes up more and more often now. And then finally, and most numerous, are the CRT actions. A council can actually commence a CRT action against a homeowner if there's a breach of a bylaw. So it can do that as well. The enforcement bylaw should also enable the strata corporation to charge back its enforcement costs against the homeowners. So that's what a well-drafted enforcement bylaw would contain. And like I said, it's meant to be a deterrent. It's meant to be a tool. People have to comply with the bylaws. All right. I think I saw something pop up in the chat, but let me just double check here. Okay, we have a question from one of the attendees saying, are modified bylaws applicable to everyone going forward? Or are there some cases where people are grandfathered? That's a great question. Grandfathering in strata corporations is sometimes controlled by the Act itself and sometimes controlled by the bylaws. The Act says that people and pets are grandfathered. So what it means by that is if you pass an age restriction bylaw, people that are living in the building prior to the age restriction bylaw being passed, that bylaw does not apply to them. Same with a non-conforming pet. If you have a 100-pound or 120-pound Great Dane living in your unit, they pass a bylaw that says no dog over 25 pounds. Your existing dog can remain in the unit. Those are the only 2 situations in the Strata Property Act where people are grandfathered by the Act itself. So a strata corporation can pass a bylaw banning smoking, for instance, and the second it's adopted and filed in the Land Title Office, it becomes applicable to everybody and does not grandfather pre-existing smokers. Now, the bylaw itself can grandfather pre-existing smokers, but if it does not contain that protection, it will apply to people going forward. So to answer Mr. Smith's response or question, in most cases, bylaws apply to the residents going forward, and people are not automatically grandfathered. Hope that answers that question. Okay, moving on. Okay. Additional bylaws that are essential to strata corporation's well-being. One of them is insurance and risk allocation. And the insurance and risk allocation bylaw is absolutely key for a number of reasons. This is the bylaw that tends to cost stratas money if they're not done correctly. Okay. Having a proper insurance and risk allocation bylaw ensures that the strata corporation is properly and fully insured. What I mean by this is, believe it or not, in British Columbia, strata corporations are required to have insurance for things like impact by aircraft. Can't remember the last time one of my stratas was struck by a plane, but I suppose it happens. But we aren't required to carry earthquake insurance. We aren't required to carry directors and officers, i.e. council member insurance. So there are some big risks that under the Strata Property Act do not require insurance. So having a good insurance bylaw will require that your strata corporation carries those insurances, and also on top of that, to ensure that the strata is appraised every 1 to 3 years, so that there is full replacement value and not short. Okay. The other thing it does, having an insurance bylaw, is it protects the strata's financial health by holding a responsible party liable. And the way it does that is by allowing the strata corporation to directly charge back a responsible owner or tenant for the loss or damage up to the strata's deductible. Okay. This has the effect of possibly reducing premium increases by discouraging careless behavior. If someone's going to be held liable for a water escape or loss or damage, they're much less likely to actually do the behavior that caused the issue. This next one's an interesting one. Under the Strata Property Act, the homeowners are responsible for the repair and maintenance of their units. Under Section 158 of the Act, if a homeowner is responsible for something, they're responsible for claims arising from it. So let's take that that little line that feeds your dishwasher. Let's say that water supply line ruptures. It's no fault of your own. It just was a manufacturing defect. It ruptures and it causes $100,000 damage to your unit and the units below you. Under Section 158 of the Act, you're responsible for that because you are responsible for the cost, or sorry, responsible for repairing and maintaining that line and the dishwasher. The same is not true for strata corporations. A strata corporation is not strictly liable should the common property fail and leak and cause damage to your unit. The playing field is not level in this situation. And what I mean by that is that the only way a strata is liable for damage or loss to your unit under the deductible is if their act or neglect caused the damage. This is a well-known fact amongst strata lawyers, a well-known fact amongst property managers. What's not well known to is personal injury and other lawyers. The personal injury and other lawyers tend to think that the stratas are strictly liable for any sort of damage or loss arising from components they must repair and maintain. So we are constantly getting bombarded by lawsuits and claims filed by owners or lawyers where they don't realize that the stratas aren't strictly liable for such loss or damage. So putting that directly in your bylaws prevents futile and spurious claims. Okay. We can also now say with some degree of certainty that bylaws can require owners to carry insurance for their contents, their alterations, and their liability for deductibles. We don't want to have to chase an owner who's responsible for loss or damage. It's better to have their insurance step in and pay for that. Recently, the Civil Resolution Tribunal has been very, very supportive of insurance bylaws requiring homeowners to carry insurance. So it's a good idea to have that. All right. So what should a well-drafted insurance and risk allocation bylaw contain? Well, should contain a requirement that the Strata Corporation update its insurance appraisals at least once every 3 years, if not yearly. Carry optional insurance like earthquake policies, officers and directors policies, legal cost coverage policies. I've noticed that Proline, by and large, has always recommended to its owners that they carry legal cost coverage so that the strata corporations aren't paying for their own legal defense should they be subjected to a lawsuit by an owner. Okay, that's a great thing to have. Legal costs can run up quickly in a lawsuit. It's a great policy to have. Put it in your bylaws so that it's there, so the strata has to carry it. Another thing that the bylaws, a well-drafted insurance bylaw should do is it should allow the strata to directly charge back a responsible owner or tenant. Note again, not just the owners, for loss or damage up to the relevant deductible. The reason for this, again, to mention the tenants, is because the Civil Resolution Tribunal has said over and over, you can't directly charge back an owner where the tenant is responsible for loss or damage. You have to go through due process against the tenant first, and then you can, if the tenant doesn't pay, you can hold the owner responsible. Okay. The bylaw should also empower the strata corporation to carry out emergency repairs. My guess is that most of your strata corporations already carry out emergency repairs, even if they don't have the bylaw. That is incredibly risky because the way that the Strata Property Act is set up, a strata corporation that does not have an emergency repair bylaw is supposed to come there in the middle of the night when the water's pouring down, try and determine whether the damage is above or below the deductible, and then following that determination, decide whether they're going to get involved in the emergency cleanup or not. The strata itself, under the Act, is only required to clean up those parts of the building that are its responsibilities to repair under the bylaws. It's not required to dry out your suites or anything like that. So having the emergency bylaw, emergency repair and emergency response bylaw allows a strata corporation to go in, respond quickly, dry everything out, then determine who's responsible to pay for what. Okay. Very important bylaw to have when the water's flowing in the middle of the night. The other thing that we do is we have bylaws that say that a strata is not strictly liable for damage caused by a failure of the common property. Just went over why that is. Again, it's more of an information piece to prevent owners and their lawyers from suing strata corporations in a futile attempt to hold a strata responsible because something failed. Okay. Again, the strata is only responsible if the failure or the loss or damage arose from the strata's act or neglect, which is often not the case. The bylaw should also require owners and tenants to carry insurance for their contents, alterations, and liability for deductibles and loss. Again, we don't want to have to go after the owners. And finally, it should require owners and tenants to report issues within their unit or the common property immediately. This prevents significant issues building up in a unit and the strata having to repair something that could have easily been addressed if it was reported earlier on. Okay, I think I saw something in the chats. There's 2 questions, so let me get to them. Okay. Is it a requirement for owners to carry their insurance or just a good idea? So I'll answer that one first. It's a great idea for owners to have their own insurance so that they aren't going to be hit by the massive insurance deductibles that we've all come to expect these days. That said, the Act does not require owners to carry their own insurance. That's why I say it's a good idea to put that in the bylaws. Bylaws can require that, but the Act does not. Okay, next one is officers and directors liability insurance. Should the bylaw state a minimum amount, and if so, what amount is appropriate in BC? Donna, I like bylaws to say what amount should be bought. I usually set that at either 1 million or $2 million for officers and directors liability insurance. Um, I don't believe you need more than that, but it's always a good idea to double check that with the Strata's insurance provider as to what they're currently recommending. I give legal advice, I don't give insurance advice, and they would know better than me. All right, so we've done insurance and risk allocation. We'll move on from there. You guys probably remember the Mayhem man from Allstate. If there's one thing for certain in strata corporations, you can expect mayhem, you can expect loss and damage. Be ready for it. Have a good insurance and risk allocation bylaw so that you can determine who is responsible for what. I'm just going to leave that on the screen for a second because I want to show you something here. Just looking for a flow chart to put up on the screen. Here it is. Okay, what I'm putting up on the screen now is a fairly detailed and complex insurance flow chart. Okay, this is how much of a mess it is to determine who's liable for what when the water flows in the middle of the night. You start on the top left-hand corner here, and you can see if the loss or damage occurs. The owner tenant notifies Strata about loss and damage. Strata engages disaster response company. So disaster response company comes, cleans, dries, determines, and makes estimates. Okay. This automatically assumes that you have a bylaw allowing the strata to carry out the emergency response. So then the first question arises, is the damage done above the strata's deductible or not? Okay. If it is above, the strata repairs common property and original fixtures in the strata lots, but not alterations, additions, or improvements. If it's not above the deductible, you have to ask what is damaged. If it's common property, the strata repairs and maintains common property and all parts of the strata lots it has to under the bylaws. If it's part of the strata lot, if the strata is an emergency response bylaw, strata can dry and repair strata lots. If it doesn't, its owner repairs and maintains damage to the strata lots themselves. We then ask who's responsible. Is it the owner or tenant, or is it the strata corporation? And then you can see how it devolves from there. If the owner or tenant is responsible for it, owner pays for cleanup and deductible and uninsured loss, and the strata charges back the owner or tenant. If the strata is responsible, you then have to ask, was the damage caused by the strata's act or neglect? If the answer to that is no, strata is liable only for the repair to the common property and parts of the strata lot it has to repair under the under the bylaws, and to investigate and dry. That's it. The owners themselves are liable to repair the damage to their strata lots. If the damage was caused by the strata's act or neglect, strata is liable for it all. So that's how complex the situation insurance is in strata corporations. Should bylaws require tenants to carry insurance? The answer to that is, in my opinion, yes. The tenants should be required to carry insurance, just like the owners. Okay. Again, the Strata Property, not the Strata Property Act, the Civil Resolution Tribunal has shown over and over again that you have to go through the tenant first to get at the owner. So just like we want the owners to have insurance to cover their liabilities, their repairs, their alterations, their contents, we also want the same for the tenants. Okay, I'll go back to slideshow now. As soon as I can find it in my share screen. There it is. All right, so we've done with insurance and risk allocation. What we're going to talk about now is anti-harassment bylaws. Yes, anti-harassment bylaws. Folks, I really, really wish we didn't have to do anti-harassment bylaws. In fact, we never used to do anti-harassment bylaws at all. Prior to about 2020, we just didn't do these things. But since 2020, the amount of harassment, owner to owner, owner to strata council, owner to strata property manager, even owners and tenants to contractors like landscapers, handymen, repair and maintenance contractors, the amount of harassment has gone through the roof. And it can get to the point where it's causing council members to quit, it's causing property managers to leave, it's causing projects to stall, it's causing you name it. It can be really, really, really bad. So we have been dealing with harassment now increasing every year since 2020. It's essential that you have an anti-harassment bylaw now. I think every strata corporation of more than 4 strata lots should have one of these. An anti-harassment bylaw does a number of things. It defines and prohibits harassment among residents, towards council members and property managers, promotes a respectful and safe living environment, provides clear procedures for addressing complaints, and supports legal action and gives some remedies should harassment persist. Okay. A well-drafted anti-harassment bylaw should define harassment. The reason it has to define harassment is twofold. First, if you do not define harassment, the Civil Resolution Tribunal is going to use its own definition of harassment, and that definition of harassment requires such intense, such overwhelming harassment that the person who is the subject to it actually suffers physical ailments as a result. We think that bar has been set too high, so we set the definitions for harassment a little bit lower than that. The definition of harassment should also include both the traditional forms of harassment that are banned under the Human Rights Code, etc., and it should also deal with the unique forms of harassment experienced in a strata context. And what I mean by this is in stratas, we often see harassment taking the form of videotaping people, following them around on the common property. We see it in bombarding council members with questions, demands for actions, demands for documents, demands for hearings. One strata corporation recently received 18 requests for strata council hearings in one night from one owner. And we're dealing with this form of essentially burying the strata in paperwork over and over again. The Civil Resolution Tribunal has looked at this form of harassment, determined that it is unreasonable behavior, and has allowed strata corporations in the past to limit the amount of interactions with individuals. So there is case law saying that you can limit some of your statutory duties to reasonable levels. Okay. So we deal with unique forms of harassment experienced in the strata context. The bylaw should also provide remedies suitable for the type of harassment they're engaged in. For instance, if someone is bombing the strata with requests for hearings, limit the number of hearings that a person can have to, say, 1 per month. Limit the number of documents that someone can require for them to reasonable levels. You can also, say, prevent someone from attending council meetings. You can prevent them from speaking at council meetings. So all of those remedies have backing in case law. Okay. You can also require that councils take only appropriate and measured steps to deal with harassment. What I mean by that is you want to avoid a situation where the council itself becomes a problem. Councils dealing with harassment can't just throw the book at an owner. They have to take reasonable and appropriate measures to deal with them. The remedies meted out have to match what the person is doing. Okay. All right, we've got some questions here. We got one that's back on the insurance question, which is, what if the damage is an act of God, storm, etc., beyond the control of the strata? Is the strata responsible for repairs to the strata lot, or is it owner's insurance? Is this something that needs to be insured by identified in the bylaws? Christy wants to answer this question. So maybe Christy, you can unmute your microphone and give a shot to that one.
Who's just leaving it for you, Justin?
Oh, okay. I'll answer it then. If it's an act of God, it's going to come back to that all important question. First question, is it insured and is it above the deductible? If it's above the deductible, the strata's insurance comes in. The strata pays the deductible. Okay. If it's below the deductible, then the homeowner's insurance is going to be responding to that. Okay. Now, the next question you have to ask is, okay, yes, there was an act of God, there was a storm, but was the strata negligent in repairing the common property? Okay. If the strata was negligent in repairing the common property, like for instance, it was a roof that gave way and the roof had not been inspected by the strata in 10 years, then the homeowner could say to the strata, your negligence was actually the proximate cause of my damage. Strata, you pay. So the first question, is it insured? Is it above the deductible? And if that's the case, the strata pays for it. If it's not insured, the next question you ask is, was the strata negligent? Okay, so again, that mess that I showed you, which is the flow chart, you'd have to walk through that. And yes, the strata can be responsible for it, even though it's an act of God, if certain parameters were met. Okay. All right. We have another one. Is it the duty of the council to report the incident of harassment to the community by way of the minutes, or can it be handled confidentiality or confidential? This actually raises two questions. First, what should be in the minutes? Minutes really should not contain personal information about identifiable individuals. Yes, the minutes should state that harassment is occurring. Yes, it should state that it's an owner or a resident doing it. It shouldn't necessarily state who is doing it, when and why, and to whom. That is a little bit much in terms of personal information that's given out, particularly if the harassment is not later found to be actionable. So yes, they should report by May with minutes, but it should not contain personal information. It should be anonymized. Okay. Does that answer your question? It should be reported, but it should be kept relatively anonymous. All right. So that's the anti-harassment bylaws. Really good idea to have that. So just stop bullying. This is a real problem, folks. I don't want to make light of it. I don't want to make light of it at all. We have seen so much harassment in strata corporations. We've even in the last few months, since about January of this year, starting to see racism rear its head in strata corporations, like explicit in-your-face racism, and that's something that I had not dealt with prior to this spring. Okay. All right. Moving on. Okay, essential bylaws, CCTV, like surveillance cameras and fob systems. If your strata corporation uses fobs that records people walking through doors, it records who walked through, when they walked through, etc., you actually need a bylaw to authorize the use of the fob system. And if you have a CCTV surveillance camera system or a video interphone system that records images, you actually need a bylaw to authorize that. The reason for this is because of the Personal Information Protection Act. That act says that if an organization, i.e. a strata, records or collects personal information, that it must have a bylaw authorizing it. It must have a privacy policy to deal with how that information is used. Okay, so the benefits of having the CCTV and fob system bylaws is A, it authorizes you to use them, because you're not authorized if you don't have it and you have to stop using them. That ensures compliance with the Personal Information Protection Act. It provides transparency on the collection and use of the data. It enhances building security while respecting privacy rights. These bylaws have to contain certain specific things. The first thing it's got to contain is it's got to contain authorization for the use of the system. It also has to set out how many cameras there are, where the cameras are located, where the fob readers are located, and importantly, where the data from those systems is stored. Is it stored on the cloud? Is it stored in the electrical room on a hard drive? Is it stored at your security provider? Where is it stored? You have to state that. You also have to state how long the data is stored. And this is something that's being in flux as of late. Recently, the Office of Information and Privacy Commissioner is recommending that the data, this personal information, the fob records or the video records, be maintained for less than 30 days. In fact, they'd prefer it to be less than 2 weeks. Right? That may be a little short, but I'm advising stratas now no longer than 30 days. Okay, it should be written over or erased. The bylaw should describe what purposes the systems are used for and when the data can be assessed. Now, this is important. We can't use the fob system or the surveillance system to monitor individuals coming and going from the strata corporation. We cannot use it to enforce minor bylaw contraventions. We can really only use it to effect safety, security, protection of property, and oddly enough, and very randomly, enforcing garbage and recycling bylaws, because there's no other way to do it. So those four things are the reasons why we can use the data that's collected by these systems. So you should say in the bylaw that they can be used for these purposes. Okay. You should also detail who can access the data and when. So normally it would be a council member and the property manager, council member and the police. It'd usually be two people, and they're able to access it together for one of these purposes. Finally, you have to detail how residents can access their own personal information that's collected by these systems. If you are recording people coming and going, they have a right to those images. Here's the problem. The problem is that if that image of the person that you've captured has an image of another person in it, you have to be able to blur out or redact that second person. That's time consuming and expensive. Okay. That's one of the reasons why the OIPC is saying that you should really keep the retention of this information to a minimum. It's for your own safety. Okay. All right, we've got some questions here. In a townhouse complex, do we need a bylaw for private doorbell cameras? Oh boy. Imagine that was the very next thing that I was going to talk about was personal video cameras. Garnet, you absolutely nailed that one, because here's the answer to your question. Lately, it's become apparent that we also need bylaws to authorize the use of personal surveillance cameras in strata corporations. Now, I could get into a monologue about this one that would probably last an hour by itself. But the way that the case law has evolved since 2019 out of the Civil Resolution Tribunal is that they have taken that long recognized requirements for strata to have bylaws to govern the strata's use of security cameras because it's required under PIPA. And the CRT has conflated that to also mean that the individual owners who want to install video cameras on common property or even use their Tesla cameras or cameras mounted on a vehicle, they have conflated those two issues to say that strata needs a bylaw to authorize individuals to use their own security cameras. That doesn't make sense. It doesn't make sense because PIPA does not apply to individuals. It applies to corporations and organizations. So the indirect application of PIPA by the Civil Resolution Tribunal has now resulted in a situation where stratas have to have bylaws so that homeowners can mount their own cameras or even use the cameras in their cars. Okay. So according to the CRT, and I don't necessarily agree with it respectfully, it ensures compliance with PIPA, prevents privacy violations, balances personal security with residents' privacies, and reduces conflict and unauthorized surveillance and harassment. A personal surveillance camera bylaw should authorize the installation and use of security cameras and vehicle mounted cameras. It should set out where cameras may be located, what the cameras can view, It should detail that the strata corporation does not have control of the cameras, or alternatively, it should prohibit the use of all of those. It should do one or the other. Okay. There are many cases, probably 4 or 5 now, that deal with personal security cameras, and there's at least 2 or 3 that deal with vehicle mounted cameras. So we know this is a problem. And according to the CRT, you need a bylaw to authorize them, or they're banned. They're deemed to be an unreasonable interference with a homeowner's use of the property. Hope that answered the question. Okay, great. Okay, moving on. Yeah, why did I go? That's interesting. It looks like the last one can't get the slide to work. The last item that I was going to talk about was the short-term rental prohibition and commercial use banning bylaws. Now that we're in an era where the long-time bylaws that many strata corporations used to have that restricted rentals are no longer legal, we're now in a situation where it's possible that individual homeowners may be able to rent out their units as short-term rental accommodation if they meet the other requirements of this Short-Term Rental Accommodation Act. Many strata corporations don't want their owners renting out units as short-term rentals and have adopted bylaws to deal with it. It's a good idea to have those bylaws because it specifies what will be considered a short-term rental. And I don't know if you guys are aware of this, but under the Short-Term Rental Accommodation Act, it's anything that's under 90 days. Again, the 90-day limit does not make sense for me from a legal standpoint, but that's the act. It's not me saying that, that's the Short-Term Rental Accommodation Act. So it's a good idea to have those bylaws because it defines what a short-term rental is. It brings in the $1,000 per night bylaw to really deter people from doing this. It usually also bans the advertisement of short-term rentals. That's usually how we find them. Okay. So yeah, those are 7 bylaws that I believe each strata corporation should adopt and the reasons they should adopt them. So please feel free to bombard me with questions or open up the mics to questions. We can take them now.
Thanks, Justin. We'll give it a second and see if anyone has any further questions. You were so efficient, you just answered them as you went along, which is amazing.
That's great. I try to anticipate people's needs.
Going once, going twice. All right. Well, it doesn't seem like there are any other questions.
Great.
That's impressive. I don't think we've ever had that. Oh,
Oh, spoke too soon.
Yeah, there were only 6 in that presentation. The 7th one wasn't loading. The screen went black and the presentation quit on me. So the 7th one was the short-term rental. It's important to have that. Yeah, according to the Civil Resolution Tribunal, if you have doorbell cameras in a townhouse complex without a bylaw supporting that, if that camera is pointed out towards the common property and you don't have a bylaw supporting that, that's contrary to, according to the CRT, it's contrary to PIPA. That's not according to me, that's according to the tribunal. Okay. And 6th bylaw was personal security cameras.
Excellent. Well, that pretty much takes us to almost 1 o'clock. I will thank Justin for attending. Thanks everyone else for attending. I know Catherine usually has some wrap-up comments, so I'm going to throw it to her to see if she has any.
Here's a question here. If the camera is strictly pointing at their own front door, is this an issue? Probably not. It's when it's recording other people on common property where it's an issue. To give you a great example of this, just Monday, I had a situation where townhouse complex homeowner had multiple cameras on their the exterior of their unit. They were actually complaining to council about what was going on in their neighbor across the lane's living room, while at the same time saying, I don't record anybody other than myself. It was clearly based on the nature of the complaints, they were looking through other people's windows.
Not good. All right. Catherine, any wrap-up comments before we call her a day?
Just a couple, and they're just housekeeping items. First of all, thank you, Justin. That was informative as always. Really appreciate it. And thanks to everyone else for attending today. As mentioned, we did record the session. We'll be sending out that link in the coming week. I'll email it to the email address you used to register for the session. So you'll see that coming in. Feel free to share the link with other council members or others that you think might be interested in learning this material. We'll also generally post our recordings to our YouTube channel, so you can usually find it and past sessions there. There's a lot of different content on there, ranging from plumbing to more bylaws to strata plans and so on. As mentioned at the beginning, if you have any questions or comments, please, there's a survey that'll pop up when you leave. Please feel free to complete that survey or reach out to me directly if you have different ideas. We're always working on new sessions, so you'll see more about them in the coming months. We're going to skip August and jump right into September because so many people are away. And that
Catherine, I'm
brings
just
me.
going to answer that last question.
Oh,
I'm going to send
great.
you guys a copy of the file or the slides once I fix that last one.
Great. And I can, I'll email that out with the email then to everybody who's registered. So they'll be able to get that, that document with that last email. Thanks again for joining us. Enjoy the rest of your day and your summer. And we'll see you again in the fall.